Section 5126 of the Constitution says that the Commonwealth Parliament has the power to legislate with respect to the people of any race for whom it is deemed necessary to make special laws. What does that mean? Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will talk about the so-called racist power in Section 5126 of the Commonwealth of Australia Constitution. This is a controversial and maybe because of that interesting provision. Section 5126 gives the Commonwealth Parliament the power to legislate with respect to specific groups of people distinguished by their race. Originally, this provision included an express exception to the Aboriginal people. The provision, however, changed in 1967. The 1967 referendum removed the exclusion of the Aboriginal race, meaning that the Parliament now has the power, under this head of power, to make special laws to the Aboriginal people as well. These removed any doubt concerning specific laws that could be made, for example, in developing a special system of Aboriginal welfare and social services. But the idea behind this provision seems to have been related to the constant influx of people from the Pacific into Australia. Pursuant to certain racial policies, the framers decided to give the Commonwealth Parliament the possibility of legislating to regulate the stay, conditions and generally the rights of these people who were of a different race. In an article from 1966, Geoffrey Sawyer has explained that Section 5126 was intended to enable the Commonwealth to pass laws which before 1900 had been passed by many states concerning the Indian, Afghan and Syrian hawkers, the Chinese miners, laundrymen, market gardeners and furniture manufacturers, the Japanese settlers and Kanaka plantation labourers of Queensland and the various coloured races employed in the pearl fisheries of Queensland and Western Australia. Such laws were designed to localize them within defined areas, to restrict their migration, to confine them to certain occupations, or to give them special protection and secure their return after a certain period to the country whence they came. Well, there is a question of whether this head of power is even necessary. There are indeed other heads of power that seem to relate to this. There is the immigration in subsection 27, the aliens power in subsection 19, the external affairs power in subsection 29, the management of the relations with the islands of the Pacific in subsection 30. Okay, I need to say that this provision ultimately bears on racial discrimination. And it is a bit weird for me to be speaking about other races and coloured races and all of that. But I'll try to follow what the High Court and what the framers of the Constitution meant in trying to explain to you what this provision is all about. But it is still important to realize that this racial discrimination can also be positive. What I mean is that, technically speaking, the provision allows positive discrimination based on race. A discrimination that brings benefits for members of a particular race. And this is especially so because Australia is a signatory to the International Convention on the Elimination of All Forms of Racial Discrimination. And this international treaty has been given effect by the enactment of the Racial Discrimination Act from 1975. So there could be laws about races that give rights, benefits or entitlements to specific racial groups, and these are positive discriminations under this head of power. Indeed, in the case of Katinieri and Commonwealth from 1998, for example, the issue was brought up. There was a question that remained unresolved of whether the Commonwealth could legislate to discriminate against as well as for the benefit of Indigenous Australians. We do not have a lot of constitutional cases related to this head of power, but in the early case of Quata and Bilky Purteson from 1982, and in the Tasmanian Dam case, there is dicta suggesting that the power is limited to laws benefiting Indigenous Australians only. By the way, we have a video about the Tasmanian Dam case. You can watch it by clicking on the top right corner, and you can subscribe to our channel so you don't miss any of our videos. But in relation to whether this provision allows for positive and negative discrimination, I should also say that there is dicta saying the opposite. Some justices have defended that a law may negatively discriminate against the people of a race. But the thing is that, as it stands today, there's no textual foundation to say that Section 5126 may only include laws that are beneficial for the people of other races. And the High Court of Australia has not clearly decided that this is the proper interpretation of this section. In fact, this prudent interpretation would seem contrary to the literal method currently adopted by the High Court when interpreting the Constitution. So, in the cases of Quata, Tasmanian Dim, and Western Australian Commonwealth, the Native Title Act case from 1995, they still establish at least three important limits on the scope of Section 5126. First, the laws must relate to particular races. It is not a power over races in general, it's specific. Second, the law must be special. It must provide a special treatment for a particular race. The law will single out a racial group to provide them with a different treatment from those received by members of the other races. And third, the law must be one that the Parliament deems necessary for the people of a race. There must be an assessment of the necessity of the law enacted under Section 5126. As Justice Gibbs summarized in Quata, the Parliament may deem it necessary to make special laws for the people of a particular race, no matter what the race. If the Parliament does deem that necessary, but not otherwise, it can make laws with respect to the people of that race. The opinion of Parliament that it is necessary to make a special law need not be evidenced by an express declaration to that effect. It may appear from the law itself. However, a law which applies equally to the people of all races is not a special law for the people of any one race. So I want you to always remember these three conditions concerning Section 5126. The law must relate to particular races. The law must be special, providing a special treatment to that particular race. And the law must be necessary. Parliament must find it necessary to legislate for that people of a particular race. I hope you have learned more about Section 51 of the Constitution and realized the complexity behind subsection 26. Make sure you have clicked the like button before you go, and I will see you next time. Until then, ciao.